section 48 sub 2. And one thing I want you to know that is so important about this law, the law empowers the immigration officer to enforce removal as soon as possible. So this means that the discretion limit that is given to the CBSE officer in this respect is limited in scope, because the law expects them and also empowers them to effect removal as soon as possible. And like I said, the officer has narrow discretion in granting a deferral. So a deferral, as I said earlier, is an officer using his discretion to stop the removal of a person from Canada who ought to be removed. And this obligation applies to the officer using the discretion, and the law expects such officer to use his discretion reasonably without threatening the discretion in this respect. So when we say an officer is not to threat his discretion or to use his discretion reasonably, and this can only be done in circumstances where there are compelling personal circumstances or in exigent circumstances, this is where the officer can exercise his discretion, and the onus is on the applicant. So what this means is that, as you've seen, it appears the law gives the officer power on one hand to remove as soon as possible. At the same time, the law expects the officer to use his discretion in compelling and prevailing circumstances, or where there is exigent circumstances. So the question comes to, how does the officer tilt the balance in removing quickly and also exercising his discretion? This now comes to you as the applicant. So you have to be the person that would persuade the officer, given reasons why you believe the officer should exercise discretion on your behalf. So it is very important that a person who is in this position seek appropriate professional advice in order to know what are the circumstances, what type of evidence do I need to be able to persuade the officer if I face the circumstances. And that is what we're going to be discussing. So there are a range of factors upon which the officer can grant a deferral request. And as I've said earlier, the obligation would always rest on the applicant. You have to make sure you convince the officer that there is a reason for the officer to exercise the discretion from removing you from Canada, or from removing the applicant from Canada. So some of these factors are: one, making effective travel arrangements. That's one important factor for the person to make effective travel arrangement. So what do we mean by this? Sometimes the person traveling may not have passports, or may not have passport for the children. And that means there is no way the person would be able to travel. So that could be a grounds for removal. But one thing I want us to take into consideration is that the Canadian Immigration or the Canadian Border Service have good relationship with the consulate of a lot of countries. So for instance, I've had clients who came from Caribbean that they've been able to effect and get travel documents themselves. So sometimes the CBSA officers can give a person the form to fill, and they themselves would get the travel documents for themselves. I've had circumstances where the client, though, has a passport to travel, and the consular officer in that country asked the client if she had a place to stay or people to meet with her, and she said she had none, and the consular ensured that CBSA made provisions for that. That is not a likely scenario, but that is one scenario. And what is usually common in this scenario is where the applicant has a Canadian-born child, and in that respect, a visa, a passport would need to be obtained for the Canadian-born child in order to be able to take the child to travel. So if the passport has not yet been obtained, then this could be a grounds for which removal can be deferred. Another one is to allow till the completion of school year. So what we need to note in this instance is that it is not enough to just tell the immigration officer that, oh, my son is, let's assume removal is supposed to be effected in January, or as this time we're speaking in May, and the school session ends in June. And you tell the officer, please allow my children to stay till June. It is not as simple as that, because as I've stated earlier, the onus rests on the applicant. So you have to be the one that would have to convince the officer. I remember we had the case in our office where we had a family that they were about to be deported. There were about 3 adults in the family with the parents, and they also had about 2 other children that were in school. And the applicant had told us that he had actually told the officer to please defer their removal till the end of the school year before we were retained, and the officer said he doesn't believe the children will be jeopardized. So what we did for them is that we did something significant. So this now comes to the type of professional assistance you get. In issues like this, experience matters, and you need to get assistance from people that know what they were doing. So what we actually did was we sat the parents down, we asked questions about the children's school information. We realized that coming to Canada, the elder of the sons had lost a year because there were differences in the academic session between Nigeria and their country of origin. And the child was able to make up. And that was about the beginning of another session. She already had the timetable exam in place. So what we did was we had to show the officer the school record prior to coming to Canada. We had to show the officer the current school record for the officer to know the child had lost a year. We did online research on educational system in the home country to show the officer that it is different from from the Canadian system. And we also showed the officer that the child will be prejudiced if the child is not allowed to complete that particular academic year. And by the time we did all that, and the officer was convinced in this instance. So you see the difference between when the applicant himself went directly to tell the officer and when we had convincing evidence to be able to persuade the officer on our client's behalf. So it is very important that when we're dealing with issues like this, evidence is very important and how it is put together. Another grounds for which deferral request could be granted is child care. The rule is that, and this is in respect of Canadian-born child, if a person is to be removed and the person has children who are not Canadian-born, definitely the children are also to be removed. But where a foreign national is to be removed and they have Canadian-born child, Canadians will always say the children are theirs and they can make provision to take care of the children. And the parents could say, okay, I want my sister to be able to take care of the children, or the child has specific medical condition. I want to hand over the child care of my children, introduce the doctors of my child, the chiropractor, the professionals that help my child in order to be able to care for the child. So this is another grounds by which removal request can be deferred. So it is very important that this is taken into consideration. I remember we had a client some time ago. The mother and the daughter are Canadian citizen, but the father is a foreign national. The mother particularly was very sick and she could not even take care of herself, not to talk of the child. And this child was about 12, very active child. She's involved in athletics. She does competitive athletics. She does competitive singing. She does some activity for the Toronto City. She's a very, very busy 12-year-old child. So he's the dad that takes her to school, attends all the school activity, takes her for all her medical care. He's the dad that takes her for all her ballet, her music class, her gyms, and all the extracurriculum activities she does. So in such an instance, if the dad is removed, who would care for the child? And the mother cannot care for the child because of her own health conditions. So in that instance, we were able to show the officer, we provided evidence of all these activities. We got letters from the places where she does this activity, all our coaches. Even we had letters from some parents in support, and we were able to use all this evidence to be able to convince the officer not to remove the father who was our client in that instance. So that is why it's very important that it is not just enough that we canvass this point, but we need to be able to convince the officer to tilt the scale on behalf of the applicants. Another grounds for which deferral could be removed is for the applicant's medical ability to fly. If you see that the next heading says the potential medical risks to flying, these two features are different. The first one is the applicant's medical ability to be able to fly. So usually this is in relation to existing medical conditions. So there's some people that have some existing medical conditions that would not allow them to be able to fly. and we need to provide this information to CBSC. So that means the person needs to provide letters from all the medical practitioners that are caring for such a person. You need to take a list of drugs such a person is using, and it's not enough for the medical practitioner in instances like this to just give a letter. We usually encourage medical practitioners to be able to show why such a person cannot fly. And usually, most times where there are issues like this, CBSA to have their own doctors. So once they receive those medical information, they pass it to their own doctors too, who would verify whether the applicant can fly or not. So once we know that CBSA is going to verify this, so it's very important to ensure that the evidence that is placed before CBSA would enhance or help their own medical practitioner to be able to make a decision. Another point is potential medical risk to flying. So you can see that the first one is inability to fly. The second one is a potential risk. So this is not a risk that is in existence. It is a potential risk. I remember sometime last year, we had a family that were to be removed, and the wife was pregnant, and the doctor had told them that the child had some, from the test they did, they realized the child needs some care and had some the deformity. And we were able to use this to convince the officer, the medical records, and the effect that if the mother should fly, especially a pregnancy that is at risk, being the way it is, the person would not be able to fly. So you can see that this is potential medical risk. It is not a risk that we know. And this is very dicey and tricky to be able to convince the officer. So a person who is bringing for this application needs to supply all the supporting medical documents, and the counsel needs to be able to advance and marshal these points to be able to tilt the officer to support them. Another one is imminent medical treatment. And usually this is a short term, and deferral generally is a short term respite. I will talk about that later. Some time ago, we also had an elderly client she had a lot of medical issues, and the doctor also suspected that she may have cancer. So she was put on treatment plan. She had one, she had a 4-month treatment plan. There was another one, she had a 2-month treatment plan. So we had to get letters from all those professionals telling us where she was at the stage of her treatment, what would happen if she were to stop the treatment, and things like that. So based on that, a removal was deferred. So the rule when it comes to deferral requests is not just putting this information before the officer, but the applicants need to professionally marshal this point to be able to tilt the mind of the officer to exercise his discretion in favor of the applicant. Like I've said earlier, the law expects the officer to enforce removal as soon as possible, and at the same time, the law expects the officer to exercise discretion. So for the officer to be able to exercise discretion on behalf of the applicant, the onus rests on the applicant to provide every information the officer would need to make a decision that would be in favor of the applicant. Some other grounds by which deportation could be stopped by the CBSA is where there is pending birth. So one thing is that a person is pregnant is not enough to stop removal. So usually the pregnancy has to be at an advanced stage. And we've had clients where they've been at advanced stage and CBSA still wants to remove them. So we had to provide letters, show history of pregnancy, why such a person cannot be removed. Where there's death in the family or burial in the family. Some few years back, maybe about 5 years or so, we had a client who had most of her family members in Canada. She's been in Canada without status for a long time. And the mom died about 2 weeks or so before, and she was to be removed, I think a week or two before the mom's burial. And we were able to convince CBSA to defer a removal so that she'll be able to attend her mom's burial. Like I've been saying, it is not just enough to write. We had to get letters from the funeral home. We had to get proof from the hospital that the mom died. We had to get letters from the other family members to support these. We had pictures, family pictures, to establish the relationship. So it is very important to be able to ensure that we provide all the information the officer would need when he's about to make this decision, and it is done in favor of the client. Another grounds could be for pending immigration application. An example is humanitarian and compassionate application. We had a webinar last week in respect of humanitarian and compassionate application. It would soon be on our YouTube channel, and I would encourage you to see that webinar. It's very, very informative. So what is an humanitarian and compassionate application? Usually it is for people that are in Canada without status, and they are begging the minister on compassionate grounds to please grant them the rights of permanent residence. So where there are applications that we think are deserving, or where the processing time we believe has gone far and decision is imminent, it could be a grounds for which removal could be stopped. And another ground is new risk that could meet PRA. We would be doing a webinar on PRA. And what does PRA mean? PRA means pre-removal risk assessment. So usually these are people that we could say are removal ready. If a person is removal ready, for instance, maybe a failed refugee claimant, or somebody who has been in Canada for any reason for a long time without status. So before a person is removed, that's why it says pre-removal risk assessment. The CBSA has an obligation to assess the risk of such a person. When we do that seminar, the information will be out for you to know. So there are also grounds and what satisfies that risk. So in this instance, if a person knows that there is a risk to the life of the person. For instance, I think some years back, we had a client who was about to be removed, and the client came to us and told us that he recently found out that his younger brother, who was in a gang in their hometown, is being sought by a rival gang, and the brother, all the family members ran away from the country because of that gang, because they were looking for him. So there was no way he would go back to the country because he would be killed to send a message to the brother. So we had to provide all those evidence before the deferral officer, for the officer to assess and see that there is a risk which was not in existence prior, but is a recent risk. And fortunately, we were able to stop the removal of that our client by CBSA. So that is another reason. So the question, as I told you here, is that if those are some of the reasons you can present to a CBSA officer to defer a removal. So what is the role of a CBSA officer in this instance? The role of the CBSA officer is not to assess risk. That is not the duty of an enforcement officer. That is the officer who is reviewing the deferral. What the officer needs to look at based on the evidence before the officer is there a potential risk if this person were removed? Is there potential compelling circumstances that warrant this person remaining in Canada and not removed at the particular time? So the officer has a little time to make the decision. The officer has a narrow window to make the decision. The officer does not have the power to assess a full risk. So that implies that the applicant has a huge task to be able to ensure that enough information is placed before the officer who has a very narrow scope to make a decision in favor of the applicant. So in summary, these are the three essential things that the officer who is assessing an application for deferral would look at. So the officer is to assess the evidence that has been submitted to establish allegation of risk or compelling circumstances or exigency circumstances. So this implies that evidence must be submitted. And like I had explained in the course of this webinar, it is not just any evidence. The evidence must be tailored towards arriving at what you want the officer to know. So this is where adequate professional experience and guidance comes in. So like the example I gave you with school, our clients that were able to get a successful deferral because we wanted a person to complete the school year. Like I told you, our client had already made this oral application before the officer, but the officer refused. So not just that we provided proof that the person was in school, we provided evidence that the person had actually lost school year previously. We provided evidence to show that if he were to return to his home country, he would be disadvantaged and lose school year again. We provided evidence of the differing circumstances of the educational system in their home country and in Canada. So it's very important that the adequate evidence is provided to the officer to make the information. So it is not just providing evidence, but the evidence that would allow the officer to make appropriate decision in the circumstances. And another one is to assess compelling circumstances. Everything is evidence, evidence, evidence. And the third one is to assess consequences and the results of removal, like the one I just shared with you earlier, where there was risk as a result of the brother of our client who was involved in gang activity. So this is the role of the officer. So the officer's decision, the law requires that if the officer is going to make a decision in respect of a deferral application, the officer must provide adequate reasons, it must be reasonable, and it must be procedurally fair. The court, by its guidance, have shown CBSA officer that although the law expects them to effect removal as soon as possible, and the law expects them to take compelling circumstances, exigent circumstances, the risk of removal into consideration, but that decision must be fair. That decision must be reasonable, and an applicant must be told the reason why you're refusing if that decision is to be refused. So what next? So the question is, if deferral is not granted, what do you do? We'll discuss that later. But if deferral is granted and the person is not removed, what next? It is very important for the applicant to know that if deferral is granted, it doesn't mean that the person has unlimited stay in Canada. So like the example of the school year I gave you, deferral is granted until the end of the school year. So that means at the end of the school year, CBSA can initiate another removal process and the process starts again. Like the example of the client I told you that we requested for deferral for the burial of the mom. At the end of the burial, CBSA could initiate another removal process. But if you recollect at the beginning of this discussion, I told us that the main fact that a person is out of status does not automatically mean the person is removal ready, in quote. For a person to be removal ready, the CBSA, which is the Canadian Border Services, would always give a person what we call a direction to report, which contains the travel itinerary, the dates that the person is going to be removed, the flight arrangement and the ticket arrangement and all that. So that is what makes the person removal ready. So at the end of the reason for which the deferral is granted, CBSA initiates that process again. So this now comes to what a client can do in the time being. A client should not use this time to just go and sleep that, oh, I have a respite from CBSA. But this is a time for a person to look at other options that is available to the person. The client I told you that asked for deferral till the end of the mother's burial, we were able to start an humanitarian application for her, and currently she's a permanent resident in Canada. There was another client I told you that had some, she was sick, she had a short time, she was given deferral short time for her to be able to attend to various medical problems she had. And because of those medical problems, we were able to apply for humanitarian and compassionate application for her. And today she's a permanent resident. So it's not a time for the applicant to go and sleep, but a person needs to seek professional advice, and the counsel will be able to look at the circumstances of the applicant and help them to decide what application they need to do to remain in Canada. So the most important thing for a person to know at this point is that granting a positive deferral request is not a time to go and sleep or rest. It is just a respite that could be initiated again by CBSA. So what if deferral is not granted? What can such an applicant do? If deferral is not granted, what the applicant needs to do is to proceed to the federal court for an application to stay the removal order. So the removal order by CBSA is in effect, and the only way that can be stopped at that point is to bring what we call a stay motion, which is a plea appealing to the federal court to please stay the removal of such a person. So when we talk of stay motion at the federal court, the stay motion itself is not an originating process. I want to say that once bringing a stay motion before the federal court, it is not an originating process. There must be an underlying application for leave and judicial review. So what that means is that there must be a reason or something you want to rely on. You know, like the proper saying goes, you don't put something on nothing. So it's just like having the foundation of a house. And when you put the bricks on the house, that is the stay motion. There has to be a foundation. So that means there has to be an underlying application upon which the stay motion is brought. So here are some examples of underlying application that could exist. So for instance, if it is an instance where deferral has been sought from CBSA earlier, and the CBSA officer refused to exercise the discretion to stop the deportation, so an application for leave and judicial review of that decision of the CBSA to refuse to stop the removal would be brought to court. So that is the underlying application. Then a stay motion application would now be brought to the court to pray the court to stop the removal based on the decision of the officer. Another reason where stay motion can be brought is if a person's refugee claim has been refused, whether by the Refugee Protection Division or the Refugee Appeal Division, and there's an underlying application for leave or judicial review of the decision of the Refugee Protection Division or of the Refugee Appeal Division, that is the underlying application. So a stay motion would be brought to court telling the court that we have an important case that would think could be resolved in favor of the applicant. So we pray the court not to remove the applicant so that the applicant can have his or her day in court. Another ground is where maybe an HNC application has been refused and there is an application for leave and judicial review to contest that decision in not granting the HNC or where a prior application has been removed. So in all these instances, there is an existing application before the court. So what we're praying the court is that we're telling the court that there is an application before the court, and that application, we believe the applicant has a likelihood of success. So we are praying the court to please defer removal so that the applicant can have his or her day in court to be able to provide facts before the court to support the application. So that is how stay motion operates. It is not an originating summon, but it is an application that rests on an existing application before the court. So if you want to plea or pray the federal court to stop removal, there is an element of this removal. There are 3 tests, and the cases you see here are the cases that brought about this test. These 3 tests are known as the tripeptide test. And when we say the test is conjunctive, what we mean is that the applicant must satisfy the court of the 3 tests. So it is not a 1/3 successful or a 2/3 successful. For you to be successful in this application, it must be a 3/3 successful application. So that's why we're using this opportunity. Our firm, we're taking our time to do free webinars like this to be able to educate people. Not only are we educating that these opportunities is available for people that want to use it, but importantly, it has to be strategically used. So that means you need the experience of counsels who know what they are doing. Because if you want to stop an application and the onus on the applicant is a 3/3, you definitely want somebody who he or she knows what he or she is doing to be able to canvass your interest before the federal court. So what are these 3 tests? What are the elements? The first one is that the applicant must demonstrate that there is a serious question or there is an issue to be tried. You know, I'd explained to you that there has to be an underlying application. So let's assume a deferral request was placed before CBSA. Please don't remove the applicant. The CBSA officer refused and insisted the applicant must be removed. We brought an application to the federal court that the CBSA officer was wrong in not removing the officer. So when we bring the stay motion before the court, we are telling the court that please grant me a stay so that I would have a day in court to be able to show the court that the officer was actually wrong in not allowing me to remain for the reasons stated in that deferral request. So the serious issue comes here that we have to be able to tell the court that the reasons why I believe the decision of the officer is wrong is serious. So that's where the serious issue comes in. The second one is that the applicant must demonstrate that he or she would suffer irreparable harm if removed. So from the example that given us earlier, when I talked of a client of ours who was to be removed, and he later subsequently found out after he came to Canada that his younger brother was involved in cult activity. The rival cult group wanted to kill the younger brother. The younger brother and all the other family members had to flee their country. So taking him back to that country definitely engages a risk or harm to him. So we need to be able to show the court in the stay motion that there is a risk or harm. And the third one is the balance of convenience. And I will discuss each and every of these points subsequently. We're going to look at what are some of the factors that the court considers to be serious questions. How can an applicant satisfy the test when we talk of serious questions, when we talk of irreparable harm or balance of convenience? How can I convince the court that there is a balance of convenience in my favor for the court to be able to stop my removal? So we start from the first one, serious issues. Best interest of the child. And I just want to explain something here. We're going to see a lot of points or factors we're going to discuss on serious issues are exactly the same factor that we discussed on deferral request. One thing we need to note is that it is not every case that comes to the court on stay motion that is premised on deferral request. From the underlying application I'd explained to you earlier. So if it were deferral request and it is based on best interest of the child, if it's deferral request that is based on that we had canvassed that we wanted the children to finish the end of the school year, or the adults, completing end of the school year actually does not end with children. We've had a client in the time past who was, she was undergoing a nursing program and she was in her penultimate year. It was during summer, she was meant to start her final year and the officer wanted to remove her. The officer and we're able to bring application to show the court that she has put in so many years. Going back to her home country, the nursing schools are radically different. So that means all the effort she's put into nursing here, the money she spent will go down the drain if she's not allowed to complete her program. The officer refused and we took the matter to the federal court. Unfortunately, we were successful. So when it comes to completing end of school year, it's not limited to school children. It could also apply to adults. So in such an instance where the officer refused to grant removal on deferral request, all the evidence we've shown would be used upon stay motion. But where there is an issue like maybe it's appeal, a refugee appeal. So a person's refugee claim was refused, the appeal division refused. We now brought an application for judicial review at the federal court. The stay motion is premised on that refusal of the refugee appeal division. So these are now issues that need to be canvassed. So that's why you see that this issue also comes up, not just limited to deferral requests. So what do we mean by best interest of the children? An applicant needs to be able to satisfy the court that removing the child at this point does not serve the best interest of the child. As I've indicated when I was explaining deferral requests, the onus in this instance as well is on the applicant to be able to provide all the evidence that is necessary to convince the court. The other side would be represented by the government lawyer, and they would also want to bring every evidence to show otherwise. For instance, in this case of Jesus Roman Cruz, what happened in that case was that there was a stepfather. He had his two stepchildren and the wife. The wife had depression, serious depression. She'd had some psychiatric treatment. She's been home. So the man had been the primary caregiver of the children for years. And evidence was brought before the court to show that the stability of the health of the children, because definitely they've suffered from the trauma of their mom's emotional trouble. So he was the one taking care of the children, all their needs, their school, their homework and everything. Every evidence was provided, letters from their doctors, their school and all that. And the government lawyer canvassed a very innovative idea. The government lawyer told the court that after all, This woman, who is a Canadian citizen, her children Canadian citizens, she has family members in Canada that could take care of the children. And also stated that the government have resources that will be able to take care of the children. But fortunately, the counsel on behalf of the applicant was able to show the court that the government lawyer are just speculating. There is no evidence before the court that the family members would be able to protect these children. The evidence that the court has is that it is the applicant that has been protecting the children, that has been responsible for their day-to-day upkeep. So you see, in that instance, it is good you have appropriate counsel, counsel that know what he or she is doing. So in that instance, the court granted the stay motion that whatever the DOJ was canvassing is not, the court does not have any evidence before them that the family member would be willing, even if they could, take care of the children. So their stepfather's deportation was stayed because of that. Another issue is impact of family separation. So if the applicant can convince the court that deporting this person would negatively impact the family, then it would be a reason why the removal will be stayed. One important cardinal principle of Canadian immigration is unification of family. Canada prides itself in promoting and protecting families. That's why we have various applications. We have sponsorship of parents, sponsorship of adopted child, sponsorship of spouse. People have opportunity. That's why even in the express entry application, if you have a family member, you have a sibling in Canada, you get extra points. That's why we have provincial nominee programs like in Manitoba and so on. And that reminds me, we're having a webinar on express entry provincial nominee in June. I'm going to tell us the date at the end of this session, but I want you to look out for those webinars. So if you have family members in those provinces, you get extra points for immigration. So that is to show that the cardinal principle of Canadian immigration is family unification. Canada is huge on that. So it is left for the applicant also to leverage on that philosophy of Canadian immigration. You'll be able to convince the court that one of the cardinal principles of Canadian immigration is family unification. So at this point, why would you separate families? So the applicants need to convince the court why families need not be separated. We had an application sometime. They were an elderly couple. The couple had been married for more than 5 years. They actually did not know. The husband is a Canadian citizen. The wife had been in Canada without status for more than 10 years, and they've been married for over 5 years. They never knew. The man didn't know that he could sponsor his wife and she would be able to get Canadian permanent residence. So by the time they came to us, she had already received direction to report. So based on her health, she's the one that I said had an appointment, medical treatment. So when we were retained, we put the medical treatment, we filed a sponsorship application, we filed an agency application on behalf of the couple. The officer refused and we went to the federal court. And one of the things the court leverage on in that application is that it makes no sense at that point, especially a couple that's been married for 5 years, to separate them. If there is a sponsorship application pending, the court stated that it makes no sense. That what sense would it make if there is a positive decision on the sponsorship application, you now bring back this wife to Canada? The court said is going to work hardship on the couple, so it makes no sense. The court granted the stay motion pending decision on the spousal sponsorship application. So on this ground, it is very important to be able to convince the court that it would impact the family unit. And it is not just emotional, but physical as well, like the example of the stepfather I mentioned earlier. So that's another point. Another point is travel arrangements, pending birth or death. I've discussed travel arrangements when I talk of people that don't have visa and passport. They need to get passport. Pending birth, I discussed that earlier, or death. We had a client sometime whose father was on palliative care, and the dad would die at any time, and CBSA officer wanted to remove the person. And it may seem a rare thing, but one thing we need to know with immigration is that the truth is that it is not everything in Canadian immigration that is written. The reason because immigration officer has a lot of discretion at their disposal. So that is why you need to be represented by counsels that have experience, and they've done this a lot of times. By that, from experience, they will be able to use innovative means and the experience they've gathered to be able to bring application before the court. I remember this client that came to us that the father was on palliative care. I've never heard of granting stay or deferral because the parents were going to die. We just thought at a firm that this should be a reasonable ground to stop removal. And we brought this application and we were successful in respect of this, that the person, especially when we also got letters from the professionals that told us that the death of the parent was imminent. So it is just good to delay the removal till the death of the family member, and that was granted. Another reason is pending H&C application. So the rule when it comes to removal is that the main fact that you have an H&C application or you have a sponsorship application in process does not automatically stop removal. That is the rule. But however, an officer can exercise discretion, or the court in this instance can exercise discretion to stop removal if we can show that there's compelling reasons to do that. And that compelling reason is evidence in the H&C application or the spousal sponsorship application, or we can show that there are exigent circumstances that is evidence in the H&C application or in the spousal sponsorship application. So it is in that instance that ingenuity comes in to be able to convince the court. And another interesting thing with all this serious issue, especially if it is based on denied deferral request, it is very important for the applicants to be able to show that this information had been provided for the officer. Most times the officer gives reasons. We have to demonstrate in the submissions before the court to show where the officer had gone wrong. We'll be able to tell the court that evidence A, B, C were provided before the officer did not engage in it. Or these are the reasons given by the officer, it is not reasonable. This is what the doctor says, this is what government doctor says, and this is the conclusion of the CBSA officer, so it's definitely not reasonable. So in such instance, it is very important to place such applications before the court. Then I discussed about completion of the school year, just like I discussed earlier in the case of one of our clients previously. So that is that with serious issues. Like I said earlier, if you recall, I said there are 3 grounds if an applicant wants the federal court to exercise its discretion by stopping the removal. There are 3 things a person needs to satisfy, and it is a conjunctive test. 1, serious issue; 2, irreparable harm; and the 3rd one is a balance of convenience. So we're going to irreparable harm. Irreparable harm is a very strict test, and the applicants need to be able to show the courts that the harm would be great if the person were removed. Example is breakup or dislocation of the family, like I've explained in the case of the children that they wanted to remove from their stepfather, or like I've explained in the case of the husband and wife that had pending spousal sponsorship, H&C sponsorship that they want to remove, or in the case of death. So in the case of death, like the client had explained, whose brother was involved in cult, removing him to the country makes him stand to be at risk of death. Or sometimes we've had failed refugee clients who, based on their sexual orientation, would want to be returned to countries that are homophobic. We need to be able to convince the court that this is the person's sexual orientation. We have to distinguish the decision of the court to the current motion and show the court that there is harm when it comes to removal of a person and disruption of school year. This case is very, very interesting because the court particularly aired there that disruption of school year could actually be an irreparable harm. For instance, the lady I told you that was doing the nursing, because the harm is irreparable, being that she was a failed refugee claimant, so that means she had to pay her school fees herself. So she was in school, spent years reading, studying, paying money, and she has a year to go, and you want everything to go down the drain. It is irreparable harm. Or like the young client I explained to you who had lost a year previously before coming to Canada, And if he were stopped and had to go back to his home country, he would lose another year, would not be able to fit in. And the court decided in this case that it is an irreparable harm. And we believe the court made the right decision in that respect. One thing when it comes to stay motion that an applicant needs to note is that on stay motion, an applicant cannot bring new evidence. So that's why, as I explained when we're discussing deferral requests, the applicants must make sure all the evidence they can provide is given to the deferral office. As a firm, we don't do application by impulse. We usually do our applications mathematically. So the question is, we ask ourselves, what do we want this application to achieve? Once we list our goal, what we want to achieve, we work back. How do we achieve this? That's the best way you can ever work. So once we know what our goal is, we now work back to see how can we establish our goal? What documents can we use to support our client's interest? Because by the time it gets to stay motion, new documents would not be allowed. The only exception is to establish irreparable harm. So when it comes to irreparable harm, when it gets to stay motion, is the only grounds upon which an applicant could bring new evidence. But to establish serious risk or balance of convenience, it is what has been placed before the reviewing officer in respect of deferral request, or what has been placed before the RAD or the CBSA officer or the IRCC officer when it comes to H&C or refused sponsorship application or refused pro-application that the court would assess. So it is very important when working on those underlying applications to ensure that all the information, all the evidence that is required has been placed before the court. And the final point is balance of convenience. So what balance of convenience means that we need to convince the court that it is in public interest not to remove a person, or we need to convince the court that based on Canadian principles, Canadian domestic and international law, removal of a person to a country where the person's life would be in danger or would be unsafe is very important. And again, the applicant needs to demonstrate that the minister will not be prejudiced. That third one usually talks about integrity of the application system. We've had instances where we've brought issues like this before the court, and the counsel, on the other hand, sometimes have demonstrated, oh, that your applicants did not come with clean hands. Some would say, oh, there is a warrant of arrest on the applicant. The applicant had gone underground for years. We're just able to find the applicant, or the applicant came into Canada as a student, had 2-year study visa. The applicant did not even study at all. We're just able to get the applicant. So the applicant does not have a good intention. The applicant does not have a good history of respecting our immigration law. Those definitely shows a negative light, prima facie, before the court. But sometimes there are exigent circumstances that this could come about. So it is for the counsel to be able to show if the person is remorse, if there are exigent circumstances, if there are reasons that make this person to behave this way. Are there other ways that the applicant has shown or demonstrated that the person had obeyed the law? So this is where the balance of convenience comes in, that the applicants need to be able to satisfy the court that when you look at the balance of convenience, it usually works in your favor. And the truth is, this balance of convenience test is, although all the 3 tests are conjunctive, is the least of the tests. If you're able to satisfy the court that there is a serious issue, there is an irreparable harm, definitely the balance of convenience will be on your side. Because the stay motion, just like the deferral request, is not an unending respite that is given to an applicant. So it just works on that. So what is the implication of a positive stay motion application? So the implication of a stay motion application is that the removal is delayed for whatever reason the application is sought. So if the application is sought for having the decision of the Refugee Appeal Division, once that decision is made, that determines what happens to the applicant. If it is pending spousal sponsorship application, if the spousal sponsorship is positive, then that's good. If it is negative, then the removal process could be initiated again. So that's why it is wise to seek legal counsel on steps to take to regularize the applicant's status in Canada. Just like I explained, if there is a positive deferral request from CBSA not to remove, and the same applies to if there is a positive decision from the federal court not to remove an applicant, then the applicant needs to seek counsel to see ways in which they could regularize their status to benefit of that respite that's been given to them. So thank you very much for listening. Like we stated earlier, if you have questions, you can type your questions using the chat feature. And if anybody wants to give an oral question, just use the raise hand feature in the Zoom app, and we'll be able to point to the person. So I'll just give 5 minutes for us to be able to reflect on what we've said, have time to type your questions, and we'll be back in 5 minutes. Thank you very much for listening. Whose refugee claim was found to be not credible. So the person went ahead to the federal court, and the federal court gave a negative decision. So the question is, what can this person do further? Where there is a negative federal court application, can the person apply for humanitarian application? Yes, the person can apply for humanitarian and compassion application insofar as the CBSA have not yet activated a removal process. The person can apply for humanitarian and compassionate application. And the person asks, how can a person obtain valid work permit again? The truth is that the negative federal court is the end of the refugee process. So a person that makes a refugee claim has access to Refugee Appeal Division and the federal court. Where the federal court makes a negative decision, the automatic right of stay comes to an end, and the person doesn't have a status at that point. So legally looking at it, a person does not have a right to work permit. But as I've stated earlier, a lot of immigration decisions are based on discretion. So if the person seeks legal advice, and the counsel will be able to look at the circumstances to know and see if work permits can be issued. These are discretionary issues. A person asks, what are the chances of this person having a PR? The truth is, I really can't answer the chances of a person getting a PR because those chances are based on discretion of a CBSA officer. But what I would rather say the question to ask is it possible for a person to obtain permanent resident status, even though the person has a respite from maybe CBSA has not called the person, they've not activated the removal process, or there's a successful deportation, or there's a successful stay motion. So in such an instance, yes, there are routes to which a person can apply for permanent residence, like some of the examples of our clients have shared with you. So a person can apply for permanent residence on humanitarian and compassionate grounds. And there are quite a number of reasons to do that. If the person finds somebody he or she loves in Canada and there's a spousal sponsorship application, it can be a road to obtaining PR in Canada. So, and the person along the line could also be entitled to what we call the pre-removal assessment, pre-removal risk assessment application, and that could also be another ground by which a person can obtain a PR. And there's another question here asking that given the COVID-19 situation in the country at the moment, is it possible that COVID-19 can be used as a grounds for irreparable harm? Definitely. Removing a person to a country, there is nowhere in the world now where applicant does not have a risk of COVID-19. So it is a very strong point for removal. But CBSA itself, they are aware of this, and the truth is currently in Canada, there is a stay on removal processes. So CBSA is not removing anybody at this moment because they are aware, just like everybody in the world, that the world is in a bit of an health crisis now, nowhere is safe. So it would, if assuming there was, that respite was not there by CBSA, it would have been a good grounds for irreparable harm. So that's all the questions I have for today. And that is all for me. Once again, I want to thank everyone for coming out to join our session. And I just want us to know that on Thursday, we have another immigration webinar on business immigration. You are invited. Please check all our social media platforms. They are there. On Friday, 22nd, making success of your legal practice. This is not limited to Canada. Managing partner, Mr. Babalola, with Anthony Digbe, Senior Advocate of Nigeria, are going to share from their wealth of experience. Both of them have combined over 40 years of experience on how to have a successful legal practice. So I'll please want you, if you have the younger ones, friends that are in law, please tell them to sign up for this. I'm sure they're really going to learn from that. May 29th, Friday, we have Canadian employment law. This is not a live session. Canadian employment law is not a live session. It is a recorded session. So we'll also ask you to look out for that. And if you have any questions you want to be addressed ahead of this, please, you can send it to us at info@TPM Attorneys. Then on May 30th, our managing partner, in line with Nigerian Canadian lawyers, is going to discuss about navigating Canadian legal practice. And one thing I want to encourage people in respect of this is that although it's basically about navigating legal practice in Canada, but I'm sure there are a lot of tidbits you can learn in navigating any profession, because the truth is that if anybody can successfully come to Canada as an immigrant and make a success of himself, you will be able to learn a lot of skills and determination, a lot of tactics that has assisted him to succeed, given that he is foreign trained. So I would encourage young people who are foreign trained, not limited to lawyers, because they would learn from this. And I also want to invite you to join me for a live Instagram session on the 1st of June. And I'll be talking on the topic of myths and facts surrounding Canadian immigration. So please invite your loved ones. The information is on our social media handle. On June 10, we'll be discussing express entry. Express entry, we know, is a skilled worker application, is the most popular Canadian immigration process. And believe you me, there are a lot of misinformation out there when it comes to express entry application. What points do you need to score? Some will tell you, I scored 7.5 in average, so therefore I'm qualified. It is not limited to that. Some will tell you, oh, but my cousin is in Canada, so I can get points for that. So the question is, would your cousin qualify to give you points in Canada? Oh, I'm over 40, I'm not able to come to Canada. Come and join this session. Please tell your loved ones, and we'll be able to share from my experience, and we'll be able to demystify a lot of questions people have in their mind and what appears to be loops or concerns in this skilled worker application. You join my colleagues, Simi and Ione, and it is an exciting session. I really want to invite you to join. And we have other sessions planned for this, so please check out our social media platforms. So from me, I really want to thank you for taking your time to join us. And as I said, look out for our social media platforms. Thank you, and enjoy the rest of your day and stay safe.